On October 22, 2019, WeMAR Government Affairs Advisory Council hosted attorneys David Brnilovich and Garrett Olexa from Jennings Strouss law firm to discuss the new Arizona LLC law and the June 2019 Arizona Supreme Court decision placing fiduciary to the LLC on members, managers, and managing members. Please welcome David Brnilovich and Garrett Olexa.
Okay, there's so much stuff with regard to the new LLC law. I went to a state bar seminar. Here's the course materials. There is so much stuff. So since there's so much stuff, we have to pack it into an hour. I have my partner who's going to help present, Garrett Olexa. He's my partner over here at Jennings Strouss. We're at 83rd and just south of Bell. And feel a little tchotchkes getting passed out, pen and a drive. So there you go. So the new LLC law, what has happened is that when the LLC Act was first brought about in the early 1990s, it was conceived as simply a holding vehicle for passive real estate investments. Within a few years, it became the go-to entity. Everybody operated as an LLC. Very few people operate as partnerships. Very few people operate as corporations. Well, the old LLC law just was bare bones. It really didn't provide for anything. So I learned that there has been a committee working on this new act for over 7 years. So that's how complex it is. The good news for most of you who operate your license under a PLLC or an LLC and you are a sole member LLC, you can continue to operate pretty much the way you have operated. The big difference is all multi-member LLCs that exist, and you might have investments in multi-member LLCs, you probably have clients who own properties or assets in multi-member LLCs. The new act substantially changes that. The old days of having a four-person LLC that owned a shopping center, for example, and they would just grab maybe an operating agreement off the internet and everybody'd sign it and life was good, that doesn't work anymore. You really, really need to concentrate on what your agreement is between the members, okay? And then once you reach an agreement on that, you have to reduce it to a written agreement. That's your operating agreement. Remember in the old days when everybody used to have corporations, they would have shareholders agreements. Partners would have partnership agreements. LLCs, people didn't have any agreements. Now you really, really need to have them. The biggest change from the old act to the new act is fiduciary duties. You all are realtors. You all know what a fiduciary is. I'm going to have Garrett explain how the fiduciary duty, how it's now imposed by the statute on not only the members vis-a-vis each other, but also on the members vis-a-vis the LLC itself. So that is a big change, and I know we're really compressed for time, so Garrett is going to handle the LLC aspect, and he's going to try to give you some direction as far as what is the concept of good faith and fair dealing, how does that differ from fiduciary duty. It's a subtle difference, but there is a difference. So, all right, I'm going to kick it over to Garrett right now.
Thanks, Dave. As Dave mentioned, you're probably familiar with fiduciary duties, but I figured I'd touch on it briefly and try and give you a little bit of a refresher on it. It is a critical component of the new LLC Act. As Dave mentioned, one of the things that the Act does is it imposes a duty not only on members to other members, but members to the LLC itself. And the fact that it imposes duties from one member to another is new. And part of why that's critical is, if you recall, when you look at the case law on fiduciary duties, it's considered one of the highest duties owed under the law. And so I would say probably the simplest way to summarize what a fiduciary duty is the fact that you as a member owe and need to put the interest of others above your own personal interests. Traditionally, I mean, these types of relationships are not only realtor to client, but they're typically guardian to ward, I mean, financial broker to client. They're typically reserved to very limited relationships. So the fact that it's now being applied to members of LLCs is a big deal. And it's a big deal because when we look through what those duties consist of, it creates new risks for potential litigation, actually. Three primary components of a fiduciary duty. There's a duty of loyalty, a duty of care, and a duty of good faith and fair dealing. What's a duty of loyalty consist of? Under the new statute, the duty of loyalty consists of a duty to account to the company for profits and benefits. That's the first component. It also consists of a duty to refrain from competing with the company before dissolution. For a lot of your clients and a lot of you, I mean, you're members of multiple LLCs. And so you're dealing with a situation here now that you have a duty of loyalty to that LLC and to the members as they exist in that single LLC. The duty of loyalty also consists of a duty to avoid conflicts of interest. There's also a duty to disclose to other members and managers any material conflict of interest. So what's material mean? Material is considered anything that would reasonably be expected to affect a member's decision. Why it's significant in part is the statute specifically says that before you vote on a particular decision, if you have an operating agreement and it says that you need a majority in interest to approve certain actions of the LLC, if there's a material conflict of interest, that would be anything that would be reasonably expected to affect a member's decision, you need to disclose to the other members your conflict. And if you don't, you're exposing yourself to liability. Second component of fiduciary duty is a duty of care. What does that mean? Duty of care requires you to refrain from reckless or grossly negligent conduct. The second component of duty of care is it requires you as a member or the holder of the fiduciary duty to refrain from willful or intentional misconduct. So what's gross negligence? What does that mean? Negligence being the reasonable person standard of care. So gross negligence is something over and above that. It's a term of art legally, but it's not particularly well defined. It's typically considered something such as if regular negligence or ordinary negligence were inattention, or you think of it in terms of a mistake. Grossly negligent is something that goes above and beyond that. So a simple mistake isn't going to constitute gross negligence, but if you have what amounts to irrational decision making or decision making that is based on known facts, where you take upon yourself essentially irrational conduct based on known facts, and there's a high likelihood of harm to someone that you're dealing with, that's gross negligence. Reckless conduct, willful conduct, those are pretty self-explanatory. Third component, again, is good faith and fair dealing. And I'll touch on that in a minute. But think about it in terms of fiduciary duty and why it's a particular cause for concern here. One, you have a heightened standard of care, right? It's over and above what was previously imposed on members of LLCs. The other thing is that with the heightened standard of care, you expose yourself to a greater risk of being sued, particularly when you're a member of a multi-member LLC. And the possible damages for breach of fiduciary duty are significant and broad. You're talking about damages for loss of money or property. You're talking about disgorgement of profits, bodily harm, emotional distress, punitive damages. Those are all elements and available potential damages for breach of fiduciary duty. So again, broad scope of damages and significant in scope. Good faith and fair dealing, what is that? You're probably familiar with it. It's generally considered to be implied in every contract. You have a duty of good faith and fair dealing. It's now a requirement and part of the LLC Act as well. And so the definition generally has not changed. The duty of good faith and fair dealing generally is defined as it prohibits a party from doing anything that will impair the right of the other to receive the benefits of the contract. So think of it in terms of it precludes you from essentially sabotaging the deal that you're in. A lack of due diligence or an intentional slacking off in your performance of a contract. Good faith and fair dealing violation? Case law says yes. Willful rendering of imperfect performance, breach of the duty of good faith and fair dealing. Interference with or failure to cooperate in the other party's performance of the contract, breach of the duty of good faith and fair dealing. The key, and one of the significant things, and Dave might touch on it again, but is the fact that under the new statute, the breach of the fiduciary duty is one that can be carved out. And so in other words, the statute creates what are essentially defaults. And if you want to carve out the default and say, look, I want to be a member of an LLC, but I don't want to be subjected to this fiduciary duty, you can put that in your operating agreement. And you can, when you do that, you agree amongst the members that you're not subject to fiduciary duties. The difference when it comes to good faith and fair dealing is the fact that the statute says you can't do that. You can't wipe out or eliminate or in any way try to limit the duty of good faith and fair dealing. So you're stuck with that regardless.
Garrett, these are state statutes that have already been enacted?
This is the new LLC Act. So it's just being imposed, when does it start, September?
September 1st of this year, existing LLC of next year. But new LLCs formed on or after September 1st of 2019 are subject to the new act.
So are you saying the existing ones, they have to change their operating agreements?
They have a 1-year grace period. But I'll talk more about that.
Yeah, because there's actually a Supreme Court decision that came down that imposes the fiduciary duty currently, actually. So you have to carve it out if you're looking to avoid that type of duty. To recap, a fiduciary duty includes duty of loyalty, duty of care, and the utmost good faith. Good faith and fair dealing, subset of the fiduciary duty, right? Duty of good faith and fair dealing prohibits a party from doing anything that will prevent or interfere with the other party receiving the benefits of their agreement. So that is kind of in a nutshell. You have a heightened duty of care with the fiduciary duty, but it can be carved out through the operating agreement. Duty of good faith and fair dealing, it cannot be eliminated and it can't be limited.
Okay, now I'll try to get through the rest of this in 45 minutes.
David, can I just let people know, if you go to WeMARGAD.org, both the podcast from Sunday as well as the blog post that went up yesterday have links to the new LLC law and Arizona Revised Statutes, as well as the court case that you read about. So if you want to read that stuff, you can do that, and then it'll help you correlate that.
Okay, the way we're going to do this, if anybody has questions, just jot them down, and we'll try to break about 10-2, and you can fire the questions at us at that point, and we'll be happy to stay over to cover any additional questions. But there is a lot of material to cover here. Like I said, the new act applies to existing corporations as of September 1st of next year. The new act applies to LLCs, I said corporations, LLCs, that are formed on and after September 1st of 2019 immediately. And in June of this year, the Arizona Supreme Court handed down a decision that found a common law fiduciary duty exists to all members of existing LLCs. So the legislature and the Supreme Court were sort of moving in the same direction. So be aware that everybody in here that is in a member in an LLC, the fiduciary duty applies to you right now. Now, what does all this mean? Let's take the primary voting, okay? Under the old act, who thought that if you owned 90% of the company and I owned 10% of the company, that when we voted, you would get 90% of the vote and I would get 10%? Who thought that? Anybody? Yeah. No. Arizona law under the old act was, unless you had an operating agreement that set forth different voting rights, it was per capita voting. Each member got one vote. So if I owned 1% of the profit interest or the membership interest and you own 99%, we had equal vote. That's now changed. So now it is the percentage of your membership interest, your profit interest controls your voting. If you want to change that in your operating agreement, you can change it. It depends on what the agreement is, what's the deal between the members. And that is a really important point. The operating agreements, as Garrett had mentioned, there are default rules under the new LLC Act. Almost all of those default rules can be modified, eliminated, or the penalties can be, for violation of the default rules, can be governed by the operating agreement. And let me touch base now too. Under corporate law, there was a theory known as the corporate opportunities doctrine. It still exists. It didn't used to exist with regard to LLCs. I'll give you a really good example. If I was a member in a 3-member LLC, and our business was buying and flipping houses. That's what we did. And we're each 1/3 members. We'd kick in the money to buy, kick in the money to hire the contractors, to fix it up, flip it, and we'd split the profits. Under the old days, if I found a house down the street that was a good buy, and I had the money, I would just go buy it and I could flip it myself. I didn't need my 2 other members. Well, the new act is and it goes with the fiduciary duty. If there is an opportunity that I become aware of to do the same kind of business, I've got to present it to the LLC. So I've got to get a hold of my fellow members and say, hey guys, you know, right down here at 9617, there's a house substantially the same. I could get it at a great deal. Do you guys want to do the deal? And I've got to present it probably by an email, so I have it in writing. And if the other partners say, yeah, I don't have to do it. Yeah, I don't want to do it. Then I could go ahead. But as you can see, you know, a lot of house flipping, that's very opportunistic. I mean, those houses come on the market at a really good price, and you got to move on them quickly. So just be aware of that. And if you take it a step further, if any of you deal with LLCs that buy dirt and entitle dirt, and then they sell it to the home builders, that is a really major deal, because if you have 3 or 4 members in an LLC, they buy the 40 acres, they put the money in, they're hiring the engineers, the attorneys to get it entitled in the city, and they're going to flip it to one of the home builders. But if I'm one of those members and I know that there's another 20 acres just, you know, in the next township that is available, I can no longer just go and take it down myself and entitle it and make the money myself. So just be aware that those are really, in your industry, those are really hot button opportunities that are presenting themselves in this market. So know who, you know, if you're involved in any of those, or if you have clients that are involved in any of those kinds of LLCs, just be aware of that. So again, you can modify that in the operating agreement. You can modify it. You can say, no, anybody has an opportunity, they can maybe take it down themselves, or if you're going to have a remnant of that, say, then you want to dictate how that opportunity is going to be presented to the other members. Here's another really big change. Distributions. Under the new act, the distributions upon a dissolution of an LLC. Let's say you have a specific purpose LLC. It was to take down the 40 acres, entitle it, sell it, and split the profits and just shut it down. Well, if that's a final distribution, you know, the new act talks about per capita distribution on a per capita basis. You really, really, really want to make sure that in your operating agreement, you specify how are the distributions going to be made. Is it going to be based on membership interest? Is it going to be based on some guys might put in more money into the deal than others? Do they get their money back first and consider it a loan, or is it just part of their capital? So just be very aware that that is addressed in your operating agreement. So let's say you have a manager-managed LLC. Okay, there's 2 types of LLCs. One type is member-managed. In other words, all the members, they run the entity. They make all the decisions. But when you get into typically larger LLCs, and again, I'll use the dirt flippers, you might have 15 members into that. Each one of them kicked in, you know, $50,000, and they take down 100 acres somewhere in Waddell. Those typically will be manager managed. In other words, everybody says, okay, Bob will be the manager. You need to specify in that operating agreement what are Bob's powers and what powers are reserved to the rest of the members. And for you as realtors, just think about this. What if Bob comes to you and he signs a listing agreement on behalf of the LLC and says, yeah, Bob, I'm Bob the manager. I'm going to hire you to list this dirt for $1.2 million. Well, how do you know he has the authority to do that? So you better, maybe, especially on deals like that, it's an obvious scenario where there's multiple members, there's a lot of money involved. You might want to ask to see their operating agreement, because you certainly don't want to take a listing on that land from Bob, he signs it as the manager, and then find out, well, wait a minute, the other members really didn't want to sell that property right now, or they didn't want to sell it for 1.2 because they thought it was worth 1.7. And then you end up in the middle of a lawsuit. And you worked to sell this property and you're not getting your commission. So look at that on the front end. And I'm not sure if the Association of Realtors is ever going to come out with forms, and they might at some point, where there's almost like a company resolution, an LLC resolution, where you have the other members sign saying, yeah, Bob's authorized to sign this listing agreement to sign this to sell this property for $1.2 million. It's probably a good practice. Or, you know, I've seen fairly large groups that, you know, several people, 6, 7, 8 people in the flipping business. And it's like, who really knows whether they have the authority to sell that house if they are using you to sell that house? Do you know if that manager has that authority? And let's step it back now. Let's assume it's a member managed LLC. How do you know that member has the agreement of his other fellow members to sell that property for $295,000 and you're taking the listing for $295,000? So just be aware. I would recommend you ask for the operating agreement when you're dealing with an obvious situation where you have an LLC as your client and you're going to be selling that property. I don't know that so much it would be an issue on the buying side, but it might be. So probably not a bad idea to ask for the operating agreement to just see that the person that you're dealing with actually has the authority to bind the LLC entity in the real estate transaction that you're going to spend a lot of time and money working. So just be aware of that. Back to the manager-managed LLC, that operating agreement should specify what actions require a unanimous vote. Like, for example, listing the property for sale. Well, maybe the manager really shouldn't have that kind of unilateral authority. Maybe that requires a unanimous vote of all the members. Or maybe it just requires a majority vote of the members, or a supermajority vote of the members. Whatever the deal is, just get it in writing. And then for you as real estate agents, look at the thing, look at that operating agreement just to know who you're dealing with has the power to do what he or she wants you to do.
Does this already affect once they're in place? It will next year.
Well, you know, on September 1st of 2020 it will, but for existing LLCs prior to September 1st of this year, that would not affect it. But your better course of conduct is to protect yourself and ask for that operating agreement. Or if you don't want to be imposed by reviewing an operating agreement, because sometimes those things are 27 pages long, just ask for a resolution. You could jump onto the Arizona Corporation Commission, see who the members are, and say, you know, I want a resolution signed by all the members saying that you, Mr. Member, you have the authority to do this. So that would be pretty simple. It's, you know, just one more step, but it will protect you from a fight amongst the members, because let's face it, that's when there's always fighting, when there's money available or when there's not enough money available. That's when, and you don't want to get caught in that. Nor do you want to get sued on that kind of stuff. I mean, you know, you get dragged into those things. And then, you know, then you have the question, oh, you know, is my E&O carrier going to cover it? Are they going to defend me? Who knows? just take that extra step, be a little bit proactive, and protect yourself.
Especially if you have a relationship with the manager.
Oh, exactly. Oh, exactly. Oh, exactly. Then another question: how do you admit new members? Okay, there's this land acquisition, dirt flipping LLC, and they have an opportunity, instead of taking down 40 acres, they have an opportunity to take down 100. And they're going to go out there and get a few more well-heeled members to come into this LLC, because they can bring in enough money to take down this opportunity. So the operating agreement really needs to dictate and control how you bring these people in. Does it require a unanimous vote from the existing members? Does it require a supermajority vote? And what terms did they come in on? In other words, what's their split out of this thing? Then, conversely, a lot of LLCs have the membership is owned by a husband and wife. So what if one of the spouses dies and you have a joint tenancy type right of survivorship, ownership of the membership interest? Well, the operating agreement should say that the survivor just steps into and becomes the owner of that membership interest, because a mere transferee, in other words, if I have a membership interest and I just transfer my membership interest to Garrett without getting the approval of the other members, he's a mere transferee. He doesn't have voting power. So address all that stuff in the operating agreement. And you could set it up however you want. Do you want a unanimous decision of the members to bring in new members? Do you want a 1/3 affirmative vote? Do you want a 2/3 affirmative vote? Do you want unanimous? It's whatever the deal is that you make with your fellow members. Get it in writing. Get it in the operating agreement. Here's another new thing that is it always existed in corporate law, but it really didn't exist under the old LLC Act, was your right to get information. Let's use again, you've invested in a dirt flipping LLC with 10 other people, and you trust Bob. He's your manager. You trust him to run this dirt flipping LLC. And you say, Bob, something's really not right here. It seems like we're feeding this beast and we're not getting any money back out. Where are the records? Let me see the records. Bob says, nah, take a hike. I'm not showing you anything. All right? Under the old law, you really didn't have the right to force the records, to force the revealing of the records, the turnover of the records. Now the LLC Act is sort of in harmony with the General Corporate Act that's been in existence for years and years. You as a member have the right to see the information. You have the right to see the financials. And you'd have the right, if you put it in your operating agreement, that the member could have his accountant look at the records. Some representative. It's a really good idea. It just keeps everybody honest. And I would take it even a step further. You could put in the operating agreement, especially if you're in the dirt flipping LLC, that it generate quarterly financials. Put it in the operating agreement. So everybody knows what's going on, because the cost of the engineer, the cost of the lawyers, all that to do the entitlements, that's expensive. How's that money going in? Who's putting it in? Is it coming in? Is it going to be coming in on a loan? Does the manager have the right to borrow that money? Does he have the right to encumber your land in order to pay for the engineering and the legal fees to entitle that property? Get all of that in the operating agreement. How about a simple thing, proxy? Can you vote by proxy? What if you're out of town? All right, put it in the operating agreement because the LLC Act does allow it if it's in the operating agreement. So if, again, you're in an LLC and you have to be out of town and there's going to be a vote, give your proxy to somebody. You know, and what's really interesting too, even, you know, at the State Bar Seminar, there was a lot of discussion for everybody who's, say, born, you know, prior to 1970. Their corporations always used to have certificates, stock certificates. And if there were restrictions on those certificates being sold to somebody else, those restrictions would be noted on the certificates. And there was a discussion. The LLC Act doesn't say anything about having membership certificates for LLCs, but there seemed to be, you know, I won't say it was quite a consensus, but there was a lot of favorable comment about maybe if you're in a larger LLC and there's a lot of money going through that LLC, it might be wise to have the operating agreement recite that there's going to be membership certificates and that those membership certificates must have a endorsement on them if there's any kind of restrictions on the membership interest being transferred. And then you can have, just like the old Corporation Act, you could have somebody in the LLC charged with keeping records of who is a member, what's their percentage of interest, have they transferred it, have they gone through the proper process to transfer it. Another new area is how do you quit an LLC? How do you get out? They used to call it withdrawal, and now they came up with the term, it's disassociation. How do you disassociate? How do you get out? Put it in the operating agreement. Specify how do you get out. If you get out, let's say, for example, you're in the dirt flipping LLC and you have a 10% membership interest, but for some reason you just cannot stay in that thing for the next 3 years until the city gets the entitlements and you could sell it to the builder. You really need to get out. Well, can you get out without causing the entire LLC to have to be liquidated? Put it in your operating agreement. If you get out, do you have the ability to pull back your capital? Put it in the operating agreement, because if you have the ability to pull out your capital, if each person in that LLC has $50,000 of capital into that thing, and you have the ability to pull out your capital, that might create a liquidity problem in that LLC because it has ongoing expenses for the attorneys and the engineers who are, you know, doing the entitlement. So just address that in the LLC. What if you're thrown out? What if your members say, you know, Bob, we're tired of you. You're out of here. You know, what are your rights? What are your rights? You have to spell all of that out in the LLC operating agreement. Just don't guess at it. And I don't know how many of you deal with these entities. I would imagine a fair amount of you deal with entities that are LLCs that own real estate, that acquire real estate, or even in other ventures. Just be aware that that LLC operating agreement, it controls everything. So, if you're in one and everybody decides that you are the pain in the neck and they want you out, you better define your rights in that operating agreement. How do you get your money out? Like, for example, you use the dirt deal again. What if they throw you out, say you're out of here, Bob, and that property's tied up for the next 5 years, you know, and there were a lot of people, if you remember back in '04 and '05, I mean, people were buying every kind of piece of dirt they could find out of, you know, 204th Avenue and Patton Road or up in New River. If there was dirt, people were buying it. And if they did not have the financial, if they didn't have the liquidity to buy the dirt in cash, a lot of people borrowed money to buy that dirt. Well, did people sign on the mortgage? Did people sign guarantees? Well, if you signed a guarantee, do your fellow members have the right to boot you out of the LLC? Well, you're still on the hook on the mortgage. All right, think about all that stuff. Put it in the LLC agreement, in the operating agreement. Okay, I'll quit pontificating. Questions?
What was the catalyst for this new statutory language?
I think the catalyst for the change was there's a national organization, and they come up with statutory schemes that are presented to the different states, and the states will adopt them or they'll modify them. For years, a really good example is that all states have some variation of the Uniform Commercial Code on the books, except for Louisiana. They don't have it. But that has been on the books in every state since the 60s. And the good thing about that is when you have a uniform act like that, if you have a decision by the Supreme Court of Nebraska that deals with a specific issue on an LLC now, well, that offers guidance in Arizona. It's not precedent, but it offers guidance as to how you deal with that problem. So they were just trying to, the problems were were numerous because people were fighting. Obviously, where there's money, there's going to be fighting. And there was even a decision by the Court of Appeals, I think that was, 2015 or so, the Arizona Court of Appeals had a decision that they handed down in a dispute on I think it was on a hotel property, and the Court of Appeals specifically found that the statute does not impose fiduciary duties on the members, and so that member who was being sued for a supposed breach of the fiduciary duty didn't have liability there, and so we were getting rulings that were sort of weird because anybody, you know, you're all real estate agents. As an agent, you have that fiduciary duty, just as an agent. And even if you're not a real estate agent, if you're any kind of agent, you have a fiduciary duty. So that decision by the Court of Appeals was sort of adverse to what everybody thought would be the law, that if you're an agent for an LLC, you have a fiduciary duty. But that ruling said, well, if it's not in the statute, then the legislature didn't want to impose it. So it created, you know, some murkiness in the law, and it not only here in Arizona, but I think it was around the country. And then, you know, most corporate litigation occurs in the big corporate states, New York, California, and Delaware, because Delaware is the home to all the companies. And it seems like a lot of LLC action goes on there too in the bigger commercial states. So if the laws are out of sync, then how do you have like an LLC in Arizona that is investing in Utah property? Well, what rights are going to govern there? What rights? Put it in your operating agreement that all your agreements are bound by Arizona law. Yes?
Speaking of that, if I had, say, an LLC in Delaware,
Mm-hmm.
and it's operating here in Arizona, how does the Arizona law affect that LLC?
You are bound by the law of the jurisdiction where it's formed, unless your operating agreement says to the contrary.
Where it's formed, so
Out Delaware.
If I have it in Delaware, then that's where it's formed, and so I'm not really affected by Arizona law.
Sort of. You know, the initial reaction, you know, is that the law of the state where the LLC is formed is going to control. Okay, you can vary that in the operating agreement, but if you are involved in a situation where the Delaware corporation is involved in real estate activity in Arizona, and it implicates the public policy of the state of Arizona, the courts are going to impose some burdens, maybe all the burdens of Arizona law on that. Just be very aware. Okay.
I'll just touch on that real briefly, though. There is, under the new statute, under 293105, it says it lists out certain things that can't be changed through the operating agreement anymore. And earlier I touched on the fact that you can't get rid of the duty of good faith and fair dealing. Well, now it also says that your operating agreement cannot change being governed by the law of the jurisdiction other than Arizona. So
if you form it in Arizona, it's controlled by Arizona law.
Exactly.
I don't know what Delaware law
So in other words,
says.
you can't form it here in Arizona and then say, hey, we want to be governed by Nevada law.
Right, I can understand that,
Right.
but I'm asking about
Right.
Arizona law on LLCs that are formed somewhere else.
If Delaware has a statute similar to Arizona statute, then it will be controlled by Delaware law.
Okay, so if you have a residential agent who's a member of an LLC that is primarily focused on acquiring properties to fix and flip.
Yeah.
That same residential agent who's a member of a multi-person LLC and acts as a fiduciary to those members is called by a past client of theirs who says, oh, I want to sell my home. And they go and they do the listing, and it's like perfect for what the LLC wants to do, but now you have a fiduciary, two different parties, should you take that listing? So,
All right. You have a duty as a real estate agent to,
protect the remote and, yeah.
and the minute you enter into that listing agreement, you have a fiduciary duty with that seller. But you can present that opportunity to your fellow LLC members and say, okay, Rose just called me. She has this house. It's a great opportunity. I can take that listing agreement, but you know what, guys? It might be a really good opportunity for us to buy because we could flip it. So you're in an inherent conflict there, and if you take that listing agreement and the seller says, okay, what's this place really worth? All right. And you run the comps and it ranges from, 160 to 190. Well, if you're going to buy it in your LLC for your house flipping LLC, your inclination is to buy it for maybe the 160 rather than the 190. So you're an inherent conflict of interest there. I would recommend that you don't take that listing. You send that listing out, and then to whatever agent gets the listing, then you say, we'll buy it as your LLC. Yes?
Question, everything we've been talking about is multi-member LLCs.
Yes.
And also the changing of the law, and that if you have an LLC already, you have 1 year to go ahead and rectify it and update it to the new law. How does this pertain to sole member LLC?
The sole member LLC is, it is a pass-through LLC. Everything drops down to your personal taxes. It's not a major impact on a sole LLC because, like I said, a lot of real estate agents have PLLCs for their entity.
So therefore, you don't have to go ahead and amend it or anything then?
No,
You stay a sole
as a sole member, you know, and just be aware that if you're married and you have a sole member, your spouse probably has a community property interest in that LLC, even though it's not stated anywhere. I mean, by law, the spouse is going to have an interest in it. So even a rudimentary agreement might be prudent. For example, the two of you agree, okay, this is Sam's LLC and Sam's married to Mary, but you know, if we ever get a divorce, it stays Sam's LLC, or vice versa. Just something like that. Yes.
If you've got a PLLC with two members that just get the proceeds from normal real estate business flowing down, does that still retain the same flow down and split for any of the processes when it was set up? Does that change?
No, but I would, if you have a two-member PLLC, so the commissions flow into that LLC and then are distributed out to the members, and they're equal members as far as the profit sharing, really doesn't change that. But what I would strongly recommend is that you have an operating agreement and that your operating agreement specifically address that. Like, for example, just think about this. You have that PLLC and you get a listing and it's a really, really good listing and there's $100,000 commission coming off that listing. Well, before the deal closes, you die. All right? Well, if there's nothing in writing about what the commission was going to split, what's to prevent your fellow LLC members say, you know, we really had a deal here. We had a verbal deal that it was going to be 90-10 on this transaction. You know, why not? Because, you know, believe it or not, in the law, you can have verbal operating agreements. You can have verbal operating agreements, just like you can have verbal partnership agreements. That's why they carried that over into the LLC Act, because a lot of people they shake the hands and they start putting the money in the deals and they do that and just roll it forward until something happens. And then everybody's reminiscence of what the deal was is 180 degrees from the other. Go ahead.
Just to follow up on his question real quick.
Yeah.
Just if I tweaked your hypothetical slightly, if instead of being 50-50, if you have two members, one owns 90%, one owns 10%. Under the new default rules, one of the things it says in terms of distributions is it has to be equal, right? So if you have $10,000 worth of income, the guy that owns 90% of the membership interest gets taxed on 90% of the income. The 10% guy gets taxed on 10%. But when it comes to the distribution, if you don't carve it out in your operating agreement, it gets 50-50, not 90-10. So that's a big significant piece that you want to carve out and clarify in your operating agreement, because the default now under the statute is any distributions are equal.
It's the phantom income problem. Yes?
Are LLCs ever affected by probate on the death of a member?
And how do you mean? Like, it becomes an asset of the estate. As soon as somebody dies, everything that person owns instantly becomes an asset of the estate. So if a member dies, his interest, his membership interest in that LLC is now owned by his estate, or his trust if he owned it in the trust. That is why you really want to have your operating agreement detail what happens in those situations, because if it goes to his estate, and suppose the deceased member has a couple kids, and those kids are going to share in the entire estate equally, well, then his 50% interest in that membership would be transferred to these children of his. Now, they won't be full participation members. They're deemed to be transferees. So it creates a lot of problems. Address it in the operating agreement. Yes?
So for clients who have existing LLCs, like investment companies, they have a group that they've been buying into, and they don't have an operating agreement in place, as agents, what should we be telling them?
Contact an attorney and get and get an operating agreement. Yeah, because you have to be very careful if you are professionally delivering services to this LLC and you are not quite sure who has the power to do what. If there's a lot of money at stake and something goes wrong, you will get sued. That's the bottom line. Because everybody knows, oh, the real estate agent, they have errors and omissions insurance. Let's sue them. All right? Pardon me?
Would a resolution help in that situation?
Oh, sure. Oh, sure. Sure. Okay, there was another, yes.
Okay, I have a question. Under an existing LLC, can the management members vote by majority to change the operating agreement, basically to their liking under the new law before their grace period is over, without the knowledge or notification to the other members?
That's a great question. How long have you been thinking of that one? All right. So an existing LLC is a multiple member LLC and one member owns more than 50%. Can that member unilaterally change the operating agreement to the benefit of that member? I would say no, because the Supreme Court in June of this year imposed the fiduciary duty, the common law fiduciary duty, on existing LLCs and their members. And I think if that scenario were to unfold, that the majority member who changed the operating agreement so it was more favorable to her as opposed to the minority members, I think would be open to they get sued for a breach of fiduciary duty on the common law fiduciary duty. So don't do that. Jackie.
Is it standard now that the ACC is going to be asking for an operating agreement with a multi-member LLC, or it's just going to be like this?
No, the ACC, especially since they went to electronic filing, it's within the last 5 years. Everything's filed electronically. And people just file crazy stuff all the time. So, there's no requirement that operating agreements be filed with the ACC. I don't think there will ever be a requirement that be filed with the ACC. But there is a statute on filing. There was a general statute before that had to do with filing false documents with any state agency, which would include the ACC. But wasn't there a specific statute?
Yeah, there's a new section of the LLC Act that deals with false filings with the LLC. So, if you were inclined to, basically say, hey, we switched membership interest and now I'm the stat agent and I own the full membership interest, and you go ahead and file that document saying that you've amended the articles of organization for the entity and you're now the sole owner of that LLC, there's now statutory liability for doing that.
And if you lose that lawsuit, you're going to get stuck with not only the damages, but also court costs and legal fees, I think, is the way the statute's written. Yeah, so it's about it. All right.
I've got a membership in a dirt flipping.
Okay.
Each LLC, each property has a different LLC.
Okay.
We've got 7 members in one, and 5 members in another. and some of the five are in both, some of the five aren't.
That's typical.
But each one is only controlling that piece.
Yes,
Has nothing to do with the next piece that we find.
right.
So when the next piece comes up, I just throw it up and say, hey, anyone of these other two want into this one? Or-
Yeah, right, that's your duty. Since you are a member, yeah, your duty now, if you find the next piece, yeah, right. If you find the next piece of dirt out there, I would send an email to the other members in LLC A and say, hey, there's another piece of dirt over here for X amount of dollars. You guys interested? Or I would say and both, because you have a fiduciary duty to both LLCs in which you're a member.
Do you have to disclose that to each other, that you may have conflicts because you're members of both?
I think the best rule is disclose. Just like your spuds. Yeah, disclose it. Yes. Oh, we're out of time. Yes.
So going along with that, if I have a brokerage, I'm a broker, and one of my agents takes the listing from LLC A, and it's multi-member, and another agent has a buyer with LLC B, how do I know as a broker that there aren't any common members in those two LLCs? What's the tool, the process I use? Because if there's a common member, I have dual agency and I don't even know it.
Well, but really, you're the agent for the entity.
So I'm into A and B, right?
Right, yeah. You're the agent for this you're the agent for entity A, and you're the agent for entity B. You are not the agent for those members. So that doesn't put you into a dual agency.
If I have a common member amongst them, they have the fiduciary, but I don't have to go figure that out.
No, because they're not your client in that deal. The LLC as an
Yeah, I get
entity.
that. But let's think about the potential of someone coming down later and say, Bob was a common member of both, and you, the listing broker, never disclosed that there was fiduciary obligations between the two LLCs. And I'm just looking at it from a risk management point of view.
Yeah.
Because like you said, we have E&O.
Right, you will be sued. Yeah.
There's a target there.
Yeah.
Okay, so that process, because we won't know necessarily who the members are.
Right.
So as a brokerage, could we come out and say, multi-member, it just has a policy and procedures thing, multi-member LLCs, we want a disclosure of members so we can figure, so that disclosure is being made between the LLCs?
I think it's not a bad practice, but then let's think this thing through. If you get a list, there's 8 members in LLC A and 8 members in LLC B, and there's 3 of them that are common. Okay, you have that information and you disclose it to who? Everybody else? And do you get everybody else to sign a waiver of a conflict of interest?
This is what I'm asking.
You know, I mean.
You just disclose, hey, by the way, guys, well, in our case, we would have a disclosure that says, by the way, there's common people amongst you.
Well, you know, if you really want to get technical, you do get a waiver of the conflict of interest. That protects you. But you got, I mean, the economics of the situation are, you don't want to irritate these people because you want to do the deal.
I want to make sure that a disclosure that's necessary has happened so that I don't get the back draft of that.
What is your thought, Garrett? I think it's a good idea to disclose it, but if you're going to disclose it, then you probably want to get a waiver, conflict waiver.
Yeah, I mean, that sounds like the conservative approach in terms of getting the waiver.
Okay.
Yeah.
All right.
We're confronted with
That's
that.
okay.
As,
They can come to you with their questions. I just wanted thinking about all the ways, because we are LLC heaven in real estate.
Oh yeah.
So I just wanted to think about things that they may need to speak about an attorney, and y'all have business cards, you know who to call. So thank you so much for coming. First of all, I want to say, make sure you pick up a cupcake in the back of the room before you leave. And I want to thank you both for coming and giving us this wonderful information so that we can start preparing our clients and being aware of this. So thank you for coming. Really appreciate it.
All right.